بسم اللہ الرحمن الرحیم۔ میں استاد محترم جناب مطہر ترمزی صاحب سے ریکویسٹ کروں گا کہ وہ اسٹیج پہ تشریف لائیں، اور سب سے پہلے میں انہیں آج چونکہ اس سال میں پہلا لیکچر شروع کیا ہے تو میں شاہ صاحب کو استاد ہونے کی حیثیت سے اور اس ادارے کو چلانے کی حیثیت سے، یہ لیگل ٹریننگ سینٹر کو چلانے کی حیثیت سے، سرپرست ہونے کی حیثیت سے انہیں آج پھول پیش کرتا ہوں۔
میں نے اسی لیے عرض کر دیا کہ 14 فروری تک تہاڈی نسبت نہیں تھی۔
اب باقاعدہ بغیر کسی تاخیر کے آج کے لیکچر کا افتتاح کرنے کے لیے میں تلاوت کلام پاک سے ابتدا کروں گا۔ میں جناب ایڈوکیٹ سعید عثمانہ صاحب سے ریکویسٹ کروں گا کہ وہ آئیں اور تلاوت سے ہمیں معزوز فرمائیں۔
اعوذ باللہ من الشیطان الرجیم، بسم اللہ الرحمن الرحیم، قل هو اللہ احد اللہ الصمد لم یلد ولم یولد وَلَمْ يَكُنْ لَهُ كُفُوًا أَحَدٌ صدق اللہ العظیم۔
اب میں گزارش کروں گا جناب صفدر محمود ایڈوکیٹ صاحب سے، جنید صاحب سے کہ وہ اسٹیج پہ تشریف لائیں، چونکہ آج جو سینئر وکلاء ہیں ان میں یہی تشریف رکھتے ہیں، اور شہباز گجر صاحب سے بھی ریکویسٹ کروں گا کہ وہ اسٹیج پہ تشریف لائیں۔ آج دو لیکچر تھے، ایک میں نے ڈیجیٹل ایویڈنس پہ آپ کے سامنے ڈیلیور کرنا تھا، اور دوسرا شاہ صاحب نے لا آف کنفرنٹیشن پہ ڈیلیور کرنا تھا۔ تو یہ ہم نے اس لیے رکھا ہوا تھا کہ اگر کسی وجہ سے شاہ صاحب نہ ہوں تو پھر میں ڈیلیور کروں گا۔ تو اس لیے اب میں ریکویسٹ کروں گا اپنے استاد محترم مطہر ترمزی صاحب سے کہ وہ اسٹیج پہ تشریف لائے اور لا آف کنفرنٹیشن پہ ہمیں لیکچر دے، ہمیں اس سے استفادہ حاصل کرنے کے لیے ہم سب حاضر ہیں۔ تو اب ریکویسٹ کروں گا کہ وہ اسٹیج پہ تشریف لائیں۔
اعوذ باللہ من الشیطان الرجیم، بسم اللہ الرحمن الرحیم۔ The topic which has been allocated for today is very important and is concern of every advocate, especially of civil side. Although it is also applicable in the criminal practice, yet it is more important in the civil practice. In the criminal practice, the previous statements are rarely confronted, especially under Section 161 of CRPC. But so far as the civil litigation is concerned, there are 101 occasions when the question of confrontation arises. I start it with an example so that we may be able to clarify it as to what the confrontation is. A instituted a suit for declaration to the effect that he was owner in possession of the property fully detailed in the plaint, and the sale deed allegedly executed by him was a forged and a fictitious document. So it was not binding on the plaintiff. The plaintiff categorically denied the execution and his signatures on the document. With consequential relief of perpetual injunction that the defendant be restrained from interfering with the possession of the plaintiff. Now the defendant appears in the court. He filed his written statement and contended that he entered into an agreement to sell with the plaintiff. He paid the amount and the registered sale deed was duly executed between the parties, and it did bear the signatures of the plaintiff. Now the controversy relates regarding the valid execution of the document, whether it was validly executed as alleged by the defendant or it was a forged document. Now issues were framed and the plaintiff was invited to give evidence. The plaintiff himself appeared as a witness of his own. It should be remembered that the original sale deed in the custody and possession of the defendant, because he is claiming ownership on the basis of that document. Now the plaintiff categorically denies the execution and corroborates his plaint. Now the counsel for the defendant appears, cross-examine him on various points, on various issues, on various relevant facts. But he fails to produce the document at the time when he was cross-examining. He did not show the document to the plaintiff. He did not ask him about the execution of the document. He did not ask him as to whether it bear the signature of the plaintiff or not. Then the evidence completed. Now the turn of the defendant came, and now the defendant wanted to prove it. The law says no, he cannot prove it. He cannot produce it. He cannot give evidence on the subject. Even the attesting witnesses of the document cannot be allowed to be produced. And that document, which is a sale deed, which is a registered document, which is properly in the custody of a person who is supposed to be in the custody, but in spite of all these things, this document is inadmissible in evidence. So the defendant shall be restrained from leading any evidence regarding that sale deed. And when the sale deed goes out of picture, it shall mean that the beneficiary has failed to prove it. And when the beneficiary fails to prove it, the contention of the plaintiff shall be accepted and the suit shall be decreed. So on the fault of the defendant or his counsel, a very precious document remains out of evidence. Why it is so? Why so much law is vigilant about the production of the document at the proper stage? Law says that the proper stage to produce the document is not the stage of evidence of the defendant, but the proper stage to produce that document is the time of cross-examination of the plaintiff. When the plaintiff was being cross-examined, at that time that document was to be tendered in evidence. At that time that was to be shown to the plaintiff. At that time that was to be confronted. And at that time the signature of the plaintiff was to be shown to the plaintiff. It is not a matter whether he denies it or not. He may deny it. He may say that these signatures are not mine. His denial carries no weight because he has already denied it in the plaint. But the matter is that he should be given a chance to explain it, whether this is the document which has been challenged by him and this is the document which he is going to rebut, and this is the document, the execution whereof is denied by him. So when the plaintiff is not given the chance to rebut that document, then the defendant cannot be given the time to prove it. It is the defendant who is to provide full opportunity to the plaintiff to rebut the same. And that is only possible when the person who is in possession of the document, who is in the custody of the document, who is relying upon the document, who is basing upon his claim on the document, he should always get it confronted by the plaintiff who is appearing as a witness. For this purpose, Article 140 has been specifically promulgated, so I would like to read and analyze the same. Article 140, cross-examination as to previous statement in writing. So the first and the foremost important thing is that previous statement should be in writing. If the plaintiff had orally said something somewhere, that cannot be confronted. It is always the statement which is in writing. But if it is not in writing, then Article 140 is inapplicable. What does it say? A witness may be cross-examined as to previous statements made by him in writing or reduced into writing and relevant to matter in question. I stop it at this stage and define it. Number one, it should be a previous statement. Sometimes it happens that the liars start confronting the witness from the statement which was recorded in chief examination. The chief examination of the witness is not a previous statement. As it is not a previous statement, he cannot be allowed to confront him with his own chief examination. It usually happens that during cross-examination, he makes a material statement which is repugnant to his chief examination. Then the defense counsel is not allowed to get it confronted from his chief examination. So the usual mistake which is committed by the lawyers is that when they get a point in the cross-examination, they start getting it confronted with the chief examination of the same witness. So do remember one thing, that the chief examination wherein the cross-examination is being conducted is not a previous statement. So when it is not a previous statement, then it cannot be confronted. Next point in it may be cross-examined as to previous statement made by him in writing or reduced into writing. In writing it means he himself wrote it. Writing means he himself wrote it. And reduced into writing means that someone else has reduced it into writing at his instance. He dictated someone else to get it recorded. It may be a vasicanis, he may be a varaisanis, he may be clerk of counsel, he may be the counsel himself, he may be the court itself, he may be the police official. Other than the person making the statement, when he makes a statement before an authority, are not any important, then that person reduces it into writing. Then that reduction in the writing shall be deemed to be the statement of the person who made it. He cannot say that it is not my writing. So the previous statement is included in the previous writing of anybody which has been done at his instance. So here the reduced into writing means that the statement is of the person, but he himself did not write it, but he asked someone to write it, and at his instance, it was reduced into writing. So when the previous statement is reduced into writing, then the cross-examiner is entitled to ask certain questions regarding that previous statement. That previous statement may be asked by him, but and relevant to matters in question. What does it mean? Relevant for matter in question. His statements of the whole life shall not be confronted. Whatsoever he did in the life doesn't matter. The matter relates to the fact which is at issue, which is a question. And when it is in question, it should be a relevant fact. Now I stop it for a moment. Then what is relevant? It is very important point that we usually have the contest on this question. If this is a relevant fact, this is not a relevant fact. We argue that it is relevant. Other argues it is not relevant, it is irrelevant. So for the purpose of understanding the world, we should understand what is relevant so that we may be able to decide that the previous statement which is going to be confronted is relevant or not. If that previous statement is relevant, then that shall be asked. But if that statement is not relevant, then no occasion to ask any question about it. Then what is relevant? So relevant is divided into two parts. One is called logical relevancy and other is called legal relevancy. What is logical relevancy? This question was several times considered by the jurists as to what the relevant is. The best definition which I found is, which I narrate before you, so that you may be able to understand as to what the logical relevancy means. Relevant means any two facts to which it is applied are so related to each other that according to the common course of events, one either taken by itself or with other facts proves or renders probable the past, present, or future existence or non-existence of the other. If the logical relevancy is considered as the meaning of Article 140, then there shall be no end to cross-examination. Because all those facts which are available in the universe may be relevant. And if you start cross-examining on the logical relevancy, nobody can stop you because logical relevancy is in infinity. Because the universe is infinity. Wherever is the universe, there are the relevant facts. So the question is, under Article 140, should we consider that it is a logical relevancy? The answer is no. Because if we consider this word relevant, that it has been used for logical relevancy, then we shall be providing an ample opportunity and powers to the cross-examiners to continue his cross-examination till his sweet will. So the law said that we are confining the relevancy up to the legal relevancy. And what is that? That has been defined in Kanun-e-Shahadat order, that whatsoever has been declared relevant In the Kanun-e-Shahadat Order 1984, that is relevant, all others are not. So, all relevant facts are not relevant. Only those facts are relevant which have been declared relevant by Kanun-e-Shahadat. Kanun-e-Shahadat order is an adjective law. It is an adjective law and defines the limits of perceptive realities. It helps us in reaching the perceptive realities. And when we reach the perceptive realities, we can try to find out the real realities. So the relevancy provided in Kanun-e-Shahadat order relates to only those facts which have been declared relevant. So when the occasion of cross-examination comes and we have to come across Article 140, we are to take into account that here the relevant means only logical relevancy or legal relevancy. This is the question. So the answer is that here is meant legal relevancy and not the logical relevancy. Logical relevancy is vast, so the law has confined it to certain facts. And the second question is in it, matters in question. What does it mean? What is a matter in question? The law, especially the jurists of the day, are of the opinion that once a party asserts a fact and other party denies thereto, then a material proposition arises. So that material proposition is a question, meaning thereby that material proposition is to be answered. As it is to be answered, this is a question. Question is answered. Where material proposition is answered, that is also a question. So here the word question means the material proposition. Number one, there should be material proposition. Number two, there should be relevant factors. Number three, there should be a previous statement in writing. Then the occasion of confrontation comes. So this Article 140 is divided into two portions. One is cross-examiner is allowed to ask oral questions when he feels that there is no need to get a document confronted and the oral examination of a witness is sufficient to draw the material facts from him, then there is no need to get the document confronted. He may seek his assistance from the relevant facts, from the question, matter in controversy, and from his previous statement. But now comes the second part. But if it is intended to contradict him by the writing, the attention must before the writing can be proved to be drawn. Before the writing can be proved, it means that the stage of proof is later than the stage of confrontation. If you want to get it proved, you should get it confronted first. But if you are not going to confront it, then it is not going to be proved. Because there are two stages. Number one is the stage of confrontation, and second, the stage that you want to prove it. If you want to prove it, but don't exercise the confrontation, then you can't prove it. So the proof of a document requires that it should be confronted to the person who is denying it as his previous statement. So the document bear certain contents. So those are contents were reduced into writing at the instance of the plaintiff. So this whole sale deed shall be deemed to be the previous statement of the plaintiff. And if you want to get it proved, then the stage of proof is later than the proof of stage of confrontation. So first you should get it confronted. And the confrontation means you are to put the original previous statement. You cannot get it confronted with a photocopy. You cannot get it confronted with any material which is not original one. So if the original is found anywhere else, then it is the fundamental duty of the lawyer of the defense to summon that record. He may request the court that he wants to get it confronted with his previous statement, which is lying in another record. Then he will apply the court that that other record should be produced so that he may be able to get it confronted. But if he does not take this exercise, then later on he cannot produce the copy thereof. That will be irrelevant, that will be inadmissible. That shall not be evidence, that shall not be proved. So, whenever there exists a previous statement relating to a matter in controversy, being a relevant fact, it is the foremost duty of the cross-examiner to summon that record, to produce that record, to show the record to the witness, and ask him about the contents of that document, and then get it confronted. It does not matter whether he denies or not. He may deny, he may admit. There are two occasions. If he admits that document, then the basic law will prevail that admitted facts need not be proved. Then the defense shall not be in a duty bound to produce any evidence on the document. If the document is put to the witness who is executant of the document and he admits his signatures and writing of the document, then the onus is discharged. Then the person in possession and custody of the document shall not be bound to prove it, because the purpose of proof has been solved, and the basic principle that admitted facts need not be proved. So when the document is admitted by the executant of the document, then the onus of the defendant is discharged. So it is at the one hand a facility to the defendant that instead of going into a long exercise of reading the evidence, he may get it confronted with the plaintiff and seek his admission of the document. So what is the law on these points? This has been developed so far, and I have got some authorities which I am going to cite. Number one, PLD 1971. Supreme Court, page 730. Party relying on admission contained in a document should put such document to other party in cross-examination in order to contradict him. Here the word contradict has been used because in his plaint and in his chief examination, he denied the document. But you want that he should accept the document. So for the contradiction of his statement, you are to put the document before him. So in order to nullify his claim, To falsify his contention, it is necessitated that the document should be confronted. If he does not accept, if he denies, well and good, you have the right to prove it. But if he admits, your onus is discharged. You will be happy, you will enjoy. Admission contained in previous statement cannot be used as legal evidence without complying with procedure laid down in section 145. 145 was section of Evidence Act. Now it is 140 of Kanun Shahadat Order. The authority relates to PL 1971 Supreme Court when Kanun Shahadat was not in the field. It was Evidence Act which was in the field, and that section carried 145 section. The section is similar to this Article 140. So the same principle shall be applicable. The principle is that if you want to use the evidence, then without complying with the procedure laid down in Article 140, you cannot lead any evidence to prove it document. Another authority, I am going with sequence, turn by turn, what is happening in the law and how the law is developing. 1994, SCMR. Non-compliance with the requirement of this section, what is its effect? Party relying on previous statement of other party embodied in a document should put the document to him and give him opportunity to explain his position. One purpose of this confrontation is that he should not be taken by surprise, because when he is filing the suit, the original deed is not in his possession. He may not be knowing what are the contents of that document. So he should also be given an opportunity to see the document, read the document, and explain the document. So the right of explanation should be given to him, and for that purpose, the document should be confronted. Without complying with the requirement, such previous statement could not be used as legal evidence. If the party fails to comply with this position, fails to comply with the law of confrontation, then the document shall not be allowed to be proved. It means that document becomes a dead letter. Keep it in your pocket and enjoy. It has no weight, it has no sanctity, it has no evidentiary value, it is not admissible in evidence. Next is 2002 YLR 2660. Execution of document. Proof of failure to confront the document to the witness. What is its effect? Where the witness was not confronted with the document, the same could not be used against the witness. That shall never be used against him. The counsel who cross-examined cannot argue that I have got a sale deed in my possession. That is a registered document. That is per se admissible. That is a public document. All arguments will be a lie will carry no weight. But if he gets it confronted, then he will find force from the question of confrontation. That at proper time, he showed the document, he confronted the document, he allowed the party to explain it, and he was not taken by surprise. So he was given an opportunity to read it again and again. He was allowed to know the contents of the document. When all this exercise has been done by him, then he will be allowed to produce the same in evidence according to the law, which is the requirement for the proof of a document. That may be oral evidence, there may be documentary evidence, that may be per se admissible. Whatsoever the mode of proof may be, then he will be allowed to adopt any mode to prove that document. But if he fails to get it confronted, he shall not be allowed to adopt any mode to prove it. There are two more authorities without wasting time. 2005 YLR 2520. It also relates to the question of confrontation. And another authority, 2011 Peshawar 208, it also fully examined the question of confrontation. So the sum and substance of this discussion is that law of confrontation is more important for the person who is in custody and possession of a document which was written, executed, or reduced into writing by the other party. If the document of other party, you keep it in your pocket, you keep it in your custody, and do not allow to see, then you will also not be allowed to see it. Thank you for the patience hearing which you gave.